Your Honor, we're here before you on a couple of matters. The first is that Mr. Jones is scheduled for PCC today. When I went over Mr. Jones's discovery, there was some sort of corruption in the file that I had. I contacted Mr. Childers to get another copy, because I do not have a copy of the lab test results. Mr. Childers indicated that there was some sort of issue with his as well, and he is attempting to get us both new copies of the police report so that we can.
At one point in time, this report worked fine because I remember reading it, but obviously not the machines emailed me. It's kind of corrupted on my end.
Okay. All right.
So we are asking for an adjournment, so we'll have more time to discuss that. In addition, it is my understanding that Mr. Jones was remanded last week on a bond violation.
Oh, he was.
What I'm not clear about is if that remand resolved the bond violation or if we are having continued hearing. We do have some additional information if the court would like that.
What is your additional information?
So I did email to Ms. Wilding a copy of my client's medical marijuana card that he had.
And as I indicated to counsel last time, the medical marijuana card wasn't a problem. It was whether he had a medical cocaine card.
That is okay. It isn't, but I did. But it was my understanding that community corrections did not have that. So I sent
the medical marijuana card. Okay,
that's correct.
They'll have.
So they now have that. The other thing is that Mr. Jones is being represented by Mr. Jeff Bennett, or had been represented by his office in Lenawee County. And Jessica Kirkland of Mr. Bennett's office did contact Lenawee County. And I do have a copy here of where she received a photograph of what I believe is the most recent test that client took there in Lenawee County. And
Which was what date?
that would be I believe, April 11th date, but I want to.
April or March 11th?
I'm sorry, I said April, but I meant March.
Okay.
With this, I believe that Mr. Jones, through counsel, explained last time that because of some issues with the test, that he had been bringing
His own test.
his own test,
Yeah.
testing there with them. So we do have, for your honor, the two copies. I
Is
received
that his test?
it's a picture. I have a photograph of both his test as well as the test that whomever the agent would have taken with him at the time. Miss Kirkland apparently called Lenawee County and received from Agent Mike McCarran the photos that were in their file of the two tests. And I provided a copy to Mr. Childers.
But hold on a second. I have Lenawee County's test that shows he's positive for cocaine.
Correct.
Then I have a test that he brought with him that indicates that he's negative for cocaine.
That is correct. However, he
Okay,
did
so
take
which
the
one
test.
do you think I'm going with?
If I could say, it's my understanding from Mr. Jones that he took the test there and that it was under observation, just like the test that they had taken. Is that right?
Yeah.
And that they opened the packaging and all of that. So I do have that, for your honor, that shows the negative screen.
He told me this the last time,
Yes.
and it still ended up in his bond being revoked. I have a test from a facility in Lenawee County. I have a test that he brought there. I guess I'm not even going to contest how it was administered. There are going to be different types of testing.
if you would like to see, his is the 5-panel test. And
Theirs was a what?
there, that is part of what his concern is in terms of when they're testing. It is it is a dipstick that is they only have in the urine for a short period of time, and then they place it like on a counter or something, he explained, and then they wait for the test results. So
If you'd
where
like a
his
hearing, we can
remain,
bring all of them up, or if Lenawee County wants to say their test, that they're gonna take his test as opposed to their own test, then I'll be more than happy to hear their sworn testimony as to why they're doing that. But at this time, what I've got is I have a test that indicates that he's positive for cocaine from a facility in Lenawee County.
okay.
I then have the defendant's test saying that he's negative.
Well, at this time, Your Honor, we'd just like to address bond if we may.
Well, does he want a hearing on that issue? Because I'll be more than happy to set a hearing.
No, he's indicated that he just wishes to address bond.
Well,
And part of that is it is my understanding from him that he was not consistently tested by the same person,
he
and that
wasn't consistently tested by who?
the same person, the same agent, and therefore, and at least
Ms.
one of
Gates,
them
have
no
you
longer.
looked at this progress report?
I have, Your Honor.
He periodically comes up with cocaine in his system.
That is what
It's not like this was a one-off
that,
on March 11th.
that is correct. Okay, so again, at this point, he is requesting that we address the bond, and he's asking, Your Honor, to consider either a release to a treatment program, or that his original bond be reinstated with him attending treatment in the community. He is a parent. He and his significant other reside together. They have 2 children and 1 on the way. He does have his own business that he works, so he helps support the family. And I believe that his child that is due within the next couple of weeks. So he is asking really very much for an opportunity. He is to be able to do some sort of treatment if Your Honor believes that's appropriate, but with his first choice, if
Is he
Your Honor would
admitting to
consider.
this violation or not?
He's indicating yes.
He's admitting to the violation of using cocaine.
Yes.
Okay. I will give him a bond. I'm not giving him a PR bond, but he wants released to treatment.
Yes. Yes.
What kind of treatment was he in before he was taken in? What was he doing besides using?
I was going to his daily reprieve. And, it's called Catholic Child. It's a substance abuse. It's a substance abuse treatment. There's 2 different types of treatments.
Okay, Your Honor, he's indicating that he was involved with daily reprieve through Catholic Social Services, and that
Was he attending it?
I had to go the same day I had court.
so
no.
let me okay, so that was what I was trying to ask you. Okay, so Your Honor, I actually have more information on that. He does have a pending matter out of 14A4, and as part of the pre-sentence things for him to do, he was to go to daily reprieve or to have an assessment for treatment. He was scheduled for that the afternoon that he was here last week.
So he has a case pending out of 14-4. What kind of case is that?
It is a use of substances.
Okay, and he was supposed to then have an assessment didn't get to that assessment.
Yeah, that is correct, because he was incarcerated that
So
day.
I don't have anything in place.
That is correct. because
So
he was-
why would I let him out?
Well, he had the appointment scheduled, and it was for the same day as the court last week. We are hopeful that he can get him scheduled again so that he can do that assessment. He is scheduled to. be
They won't
sentenced in
come to do
front of-
the assessment there in jail?
No, they will not. Mr. Brown is representing him on that matter, and it's my understanding they will not.
Have 14-4 seen this report
Mr.
with the
Mr.
cocaine?
Jones is indicating that they have.
When was the last time he was in court at 14-4?
Last week.
And so now they've seen this. What's his bond on that case?
On a PR. He was scheduled for sentencing and referred to get an assessment in Lenawee County where he resides.
Correct.
And he was arrested before he could obtain. He's scheduled for sentencing in JIS.
I think it's April 24th or 23rd, something like
Do
that.
you have proof of his appointment?
Proof of his assessment.
Yeah, when was that set?
I'll get my computer.
I'll pass this matter. You can take him back because my inclination is not to let him out, but I'll take a look at whatever you got.
Troy Gaines, Senior Assistant Public Defender representing Mr. Jones. You had requested verification that Mr. Jones was scheduled for a substance abuse evaluation last week, March 14th. Mr. Jones was in fact scheduled. I was able to obtain verification showing that he had an appointment on March 14th at 12 o'clock noon. With the testing agency, pardon me, with the assessment agency.
Okay, I see that, but and they won't see him.
That is my understanding from Mr. Brown. That's the agency. That's one of the agencies, according to Mr. Brown, that 14.
When was he set for sentencing?
I want to say April 23rd, or was it the 22nd? April 23rd.
He was, no, I know when he set this time, but when was he was going to do the assessment. When was he set for sentencing after that assessment?
23rd. So in about a month.
Defendant having admitted to the violation, I'm not going to give him a straight PR. He'll need to set the appointment. I'll let him out prior to sentencing. I'll sentence him on that on the violation of 28 days. I'll give him credit for 21 days. So I'll serve an additional 3 weeks. He should get it out in time then to do his assessment and then properly be sentenced before Judge Freshour.
Right. Thank you.
In this court hearing, the matter involved Mr. Jones, who appeared before the court on two related issues: a scheduled pretrial conference, PCC, and a bond violation stemming from repeated positive drug test results. Defense counsel first requested an adjournment of the PCC because both defense and prosecution were unable to properly review discovery. The police report and lab test results were corrupted, and both parties were waiting for corrected copies from Mr. Childers. The court accepted that the discovery issue justified an adjournment so the case could be properly reviewed later. The more serious issue concerned Mr. Jones's bond violation. Defense counsel explained that Mr. Jones had been remanded into custody the previous week and sought clarification on whether that remand resolved the bond violation or whether the court was continuing to consider it. Counsel submitted additional information, including proof that Mr. Jones possessed a valid medical marijuana card, though the court made clear that marijuana was never the issue. The court emphasized that the violation concerned cocaine use, not marijuana, and noted that there is no such thing as a medical cocaine card. Defense counsel then presented conflicting drug test evidence from Lenawee County. One test administered by the county showed Mr. Jones tested positive for cocaine, while another test brought by Mr. Jones himself and reportedly taken under observation showed a negative result. Counsel argued that the discrepancy might be due to differences in testing methods, explaining that Mr. Jones's test was a 5-panel test, while the county's test used a dipstick method that may be sensitive for only a short time. Counsel suggested that inconsistent testing procedures and different supervising agents contributed to unreliable results. The judge rejected this argument, stating clearly that official tests conducted by a county facility carry more weight than tests brought in by a defendant. The court also noted that Mr. Jones's history showed multiple cocaine positives over time, not just a single isolated result. This pattern undermined any claim that the March 11th positive test was a one-time anomaly or testing error. At that point, the defense shifted strategy and requested that the court address bond only. Rather than setting a hearing, Mr. Jones asked for release either to a treatment facility or under reinstated bond conditions with community-based treatment. Defense counsel emphasized Mr. Jones's family responsibilities, including 2 children, another child due soon, and his role as a business owner supporting his household. When questioned directly, Mr. Jones admitted to violating bond conditions by using cocaine. This admission significantly changed the court's analysis. The judge stated that while a personal recognizance (PR) bond would not be granted, the court was willing to consider release to treatment. However, the court required proof that treatment was actually arranged, and not merely proposed. Further discussion revealed that Mr. Jones had a pending substance-related case in another court, one for a district court, and was supposed to complete a substance abuse assessment as part of that case. He had an appointment scheduled for March 14th, but he missed it because he was taken into custody. Defense counsel later provided written verification confirming that the assessment appointment had indeed been scheduled. Despite this, the judge expressed concern that no treatment was currently in place and that agencies would not conduct assessments while Mr. Jones was incarcerated. Given his admission to cocaine use and the lack of an active treatment plan, the court declined to release him immediately. Ultimately, the court ruled that because Mr. Jones admitted the bond violation, he would not receive a straight PR bond. Instead, the judge imposed a structured resolution. Mr. Jones would serve additional jail time, receive credit for time already served, and be sentenced on the violation within 28 days. This timeline was designed so that he could be released in time to complete a substance abuse assessment and proceed properly with sentencing before the appropriate judge. The court's decision balanced accountability for repeated cocaine use with a limited opportunity for treatment, but only after further custody time.
And what were we intending on doing today?
Well, Your Honor, there's 2 things. One is a pretrial, and I was also informed prior to today that there was a violation.
There is correct.
I'd like to address the violation first, if that's okay with the court.
That would be what I think needs to happen.
Your Honor, Ms. Reiser and I did have an opportunity to review the violation report. I did indicate to my client that on 2 occasions, one in February and one in March, there was a small amount of alcohol in his system. I'm going to assume for the sake of argument that all of his other tests were there was no positive result. Your Honor, I explained it to my client. My client indicated to me that he does use on occasion mouthwash. And on those 2 occasions, that's why there was a small amount of alcohol in his system. The court notes that I believe I don't have
that's what he told you.
Yes.
And that's why you're relating that to me?
That's exactly right, Your Honor.
Okay.
Your Honor.
Keep going, please.
I'm sorry?
Keep going.
Okay, I don't have the report in front of me, but I believe both of those were in the evening. It's part of his evening process.
You can look at it. Because those, did you? Because those are, what kind of mouthwash?
Yeah. 0.021 and 0.023 is that what you're referring to, Your Honor?
Yeah, but then what is more disconcerting with the excuse that your client is giving you that you are relating to the court is that then there's a retest. So that mouthwash was hanging around for a while.
Well, Your Honor, let's see, 11:32, about a half an hour on this one and it was going down. And about a half an hour, well, yeah, a little bit more than half an hour on this one and it was also going down.
Those the same days?
No, one is on the 25th.
Yes.
And one's on the 22nd, for February 25th and March 22nd.
The other one, so the one that
You don't tell me, tell him.
I'm sorry.
Yeah, approach him.
I got it.
So the first one was after, I know was February, was after the football game.
Was what?
I'm watching the NFL football game.
Yeah.
I watched the game. I went in, brushed, and right away blew, and it didn't register. So then I waited till the required time and watched another TV show, and then blew a compliant test. And then the second one was after I waited 30 minutes after popcorn brushed, rinsed my mouth again, then waited 10 minutes, and then blew, and it's worked.
Your Honor,
So then I waited for retest, and the retest was okay.
Your Honor, after looking at the report again, I noticed that both tests were in the evening. I'm assuming, since there are no other tests referenced, all the morning tests were negative, and all the other evening tests were negative except for those two. That's all I can say at this time, Your Honor.
I've never heard of mouthwash lingering that long, first of all. And that mouthwash, particularly as it's being described, would hang around that long to blow numbers. And I'll be honest with you, I don't believe it
Okay.
at all. But if that's your story, then that's a story you're going to give me, and then I got to do what I got to do. Is that really what happened?
Yeah, I was up late watching football. Yes, with my girlfriend.
I don't doubt that. I'm just saying, you're saying that's the reason for the alcohol. Is that what you're telling me?
That's what I want to tell you.
Okay, I understand what you want to tell me.
No,
I also understand. I didn't just wake up yesterday and start doing this. So I want to make sure that that's what you want to tell me
well,
before I do what I have to do.
There-
If that's your story.
no, sir, that is not.
That is not what.
That is not my story.
Okay.
I
So now you have lied to the court. You lied to your attorney so that they could lie to the court. So you want to tell the truth or not?
I'm with my girlfriend while we were watching.
What'd you do
Had a glass of wine. Had a glass of wine with my girlfriend.
on both of these occasions?
She drinks wine.
Yeah, that's what I thought happened. You actually drank. So if you did that, why'd you lie?
Because all the other times I was good. I haven't touched. I haven't wanted.
Oh, I know that. So
Honestly,
why did you lie?
because I knew it was wrong.
What?
I knew it was wrong to have those glasses of wine with her.
So why didn't you just admit that you had it?
Because
see, now what I have to do is I have to then release you theoretically on an I have to release you theoretically. You're here on an OWI second. I put you on testing or monitoring system, blow numbers. Then you come before the court and you lie to me. What?
I apologize to the court.
What were we intending on doing on the case?
Your Honor, I did have an opportunity to discuss the matter with Ms. Reiser. We were going to ask for about a 30-day adjournment. She indicated she was not going to make an offer until my client earned an offer.
Yeah. This probably didn't help.
Ms. Reiser knew about this, Your Honor, before she made that comment.
Yes, I'm sure she did. Guess it wouldn't be wise to adjourn this out 30 days. I'll adjourn this matter to April 17, 2021 at 9 a.m. Or as your invite indicates. I will find that the defendant violated his bond conditions of no alcohol use. The defendant's bond will be set at $25,000. I'll give a 10% privilege at this time on it, but defendant, if he posts that bond, cannot be released from custody without a scram tether, and it must be in place. Defendant is remanded.
In this hearing, the court addressed both a scheduled pretrial matter and a bond violation involving the defendant, with the court choosing to address the violation first due to its seriousness. Defense counsel acknowledged, reviewing the violation report, and informed the court that on 2 separate occasions, one in February and one in March, the defendant tested positive for small amounts of alcohol, while all other tests were negative. Counsel initially relayed the defendant's explanation that the alcohol readings resulted from the use of mouthwash during his nighttime routine. The court, however, carefully examined the test data and noted that each positive result was followed by a retest showing declining but still measurable alcohol levels, which the judge found inconsistent with mouthwash exposure. When questioned directly, the defendant first repeated the mouthwash explanation, describing the circumstances surrounding the tests, including watching football and evening routines. The judge expressed clear skepticism, stating that mouthwash does not linger long enough to produce the reported readings over multiple tests, and warned the defendant that the court needed the truth before making any decision. Under further questioning, the defendant admitted that he had in fact consumed alcohol on both occasions, explaining that he drank a glass of wine with his girlfriend and lied because he knew it violated his bond conditions and feared the consequences. The court responded firmly, stating that the violation itself was serious, but that lying to both his attorney and the court significantly worsened the situation, undermining trust and accountability. The judge emphasized that the defendant had been placed on alcohol monitoring specifically because of prior offenses and was expected to comply fully and be honest if violations occurred. Following this admission, the court found the defendant in violation of his bond conditions for consuming alcohol. Regarding the underlying case, defense counsel requested a 30-day adjournment, noting that the prosecution was not prepared to make an offer until the defendant demonstrated compliance, but the court declined a lengthy delay in light of the violation. The matter was adjourned to April 17, 2021. At 9 a.m., the court then reset the defendant's bond at $25,000 with a 10% provision, ordering that if the bond were posted, the defendant could not be released without a SCRAM alcohol tether installed. The defendant was remanded into custody, with the court making clear that the decision was driven not only by alcohol use but by the defendant's dishonesty during the proceedings.
Your name?
Eternity Jackson.
All right. Before we begin, who escorted you to the court today?
Myself.
Pardon?
Myself.
Or were you with
My grandfather.
your grandfather?
Yeah.
All right, sir. I realize you wanted her case called, but I'll just give this admonition. I call the cases in order as I have them by their blocks. We're not going to call this thing at 9 o'clock, and I don't appreciate ever my staff being yelled at. Or you trying to send them back to pose a question to me.
Well, you know what, Your Honor? Okay, y'all sent out a letter saying 9 o'clock, all right? If y'all do so.
Ma'am, sir,
Yes, sir.
it isn't even your case. So have a seat. Have a seat. Have a seat. I've given my admonition. That's the way that it will roll. Ms. Reiser, you have something on this case.
Yes, Your Honor. The public defender did provide me with proof of now there is an insurance policy for 6 months. Given that pre-arraignment, I would move to dismiss the charge.
And you're not on the case. Ms. Jackson, you have any objection to dismiss?
No.
Case is dismissed. Thank you, ma'am. You know, how many people have I taken into custody today?
One.
Just one?
Yeah.
There was almost two. And I tried so hard. I'm proud of me.
Good.
June 7th, 2024. Mr. Howard's like, he's not talking about me, Mr. I said, I could see him sweating. June 7th, 2024. That's at 9 a.m.
Bridget Coons on behalf of Ms. Johnson, state your name for the record.
Ayanna Johnson.
Your Honor, this one also has a bond violation.
Oh, yes, it does.
Addressed first. So there is a few late tests, quite a few. I did speak to Ms. Johnson. She was under the impression that the test was supposed to be from 9 a.m. till 12 p.m. And that kind of does reflect on these missed tests, as almost all of them, or late tests, as most of them are submitted between the 9 to 12, it looks like.
Well, except for, no, I see what you're saying, but
Okay. On March 12th, I do see one was submitted at 9:34. She gets off of work at
right.
1 p.m.
No,
Yeah.
hold on. I just want to make sure we're clear. On the 12th, there are two tests. If you look at the very first two entries, the first test, it was a 6 a.m. to 9 a.m. test. She didn't test until 9:34. Then on that same date, there's a test between 12 to 3. That one she missed entirely
I see.
and didn't retest.
Well, I have had the opportunity to clarify the time for her. We anticipate no further violations. After all, that she has never tested positive once for alcohol. So we'd be asked that she be allowed to continue on bond, and then to adjourn this to allow more tests to come through to prove that she is a good candidate going forward for resolution on this case.
Is she really going to be able to do this? Because if I do that, any more missed tests, then she's going to go.
Okay, I just need to know what times I need to know the correct time.
Well, they gave you the time.
That's what I'm saying though. So that's on, they gave on the paper, it say from 6 a.m. to 9 a.m. and then one from 12 to like 3 o'clock. And then the other one say 9 to 12 a.m.
Well, yeah.
So I
Right.
I got my alarm clock set for 9 o'clock p.m., 1:30 p.m. and 9:30 p.m. That's not right.
So you're basically, your alarm clock is going off a half an hour into the testing schedule.
Is it?
Well, I don't know.
I think you
Okay,
need to-
look, ma'am, the test that you're missing, Miss Coons is right. The 6 a.m. to 9 a.m. test fundamentally is the test that you're missing.
Okay, so I'm just taking it too late.
Yes,
Okay.
but that's a miss.
So you got to reset your alarm maybe to 9 or 8 a.m.
Yeah.
Or 7.
Yeah.
Or 6.
Yep.
Somehow or another, that 6 a.m. to 9 a.m. test, you've got to get in.
Okay.
You're right, you do tests, but some of these tests are an hour and a half, almost 2 hours after the end of that period.
Okay.
And so what I'm saying is, I'll give you another shot, but you need to understand something. If I have another missed test, because I should really consider all of these tests positive. Okay. But if I give you that chance, if I have another missed test,
I'm gonna go to
then I got it. Yeah, I got to do what I got to do. Now, the other option is I can switch you over because of this violation. I can switch you over to a scram test.
What is that? On my ankle?
Yes.
Why are you yelling at me?
I'm not yelling.
I'm giving you, normally I don't give options. I don't know why I feel so generous today. I know, it's like unusual.
It's on your ankle. You don't even...
Usually if I had a report like this, ma'am, I'm going to tell you, you'd be going to jail right now.
Okay.
So what would you like to do? Take the chance that I let you go and you test on time, or you want to scram tether?
Is that gonna like dig into my ankle and like, how do that work? I don't know what that is, so I gotta ask.
They put it around your ankle,
Uh,
and then if there's any alcohol consumption, we're gonna know.
how long I gotta wear it?
I guess the best answer until I say you don't.
Hmm.
I know this is hard because
I can't walk around.
no,
with
it's I know fashion. Go girl.
Yeah, I can't walk around with
I mean, I don't know.
tether on my
What do you
ankle.
want me to say?
I'll just do the blow. I'll
You
just,
really?
yeah, I'll do it on time. I'm gonna change my alarm. I can't walk around with no tether.
Really?
I mean, if I ain't got no
You
choice,
could.
I mean, I could, but if I got a choice, I'd rather blow.
I know. Emily, your tether didn't go with any of your outfits, did it?
Like what?
I'm sorry.
I'm not wearing that.
I'm just. I'm just. Okay, I'm sorry, Emily. Didn't mean to let that out like that. Defendant to have no further missed tests. When did you want this adjourned out to?
Can we have a month?
And I'll adjourn this. You gonna make it a month? What? Why are you looking at me like that?
I'm gonna make it.
I'm just at. Okay.
I'm gonna make it.
No, I'm gonna put it in the file. She said she gonna make it. Then when you don't, if she doesn't make it, don't be begging me to do anything different. I gave the warning.
Thank you. What was the date on that, Your Honor?
Seriously,
Sorry.
May 1st.
Thanks.
Thank you.
You're welcome. I think though that if you get a black outfit, the tether goes. It's okay. I'm just. Thank you.
Judge, so thank you for informing us about the bond violations, but we have.
You're welcome.
She admits that she missed them, but she has been seeing a mental health specialist to get on medicine to help with her panic attacks. She's been on it for about a month. She complained last week that they were making her tired. And the reason she got on them is because she wasn't sleeping well and was having panic attacks. So that's why we believe she was missing the test, because she couldn't get herself up and stuff. So just like the last person, assured me that she won't.
No counsel has learned.
Yes. Well, usually I'm on Zoom in front of you, Judge, so.
I know. We were actually mentioning that because I've never seen, I don't think you've been in person.
No.
No. But go ahead.
So I'm asking to give her another chance, asking for an adjournment. I think we're going to get close to resolving this case by the time we come back. Like I said,
Okay.
have discovery.
In all seriousness, they're adjusting your medication.
Yeah.
So,
And to be honest, she's only been on it for about a month now. So the first
right.
tests were.
And so my concern is just like, well, not quite like the last person, but I can do this, but if you miss another test, we're going to have a problem.
Understood.
Or I can switch you to scram.
I'm okay with the blow. I'm
You're okay with,
blowing in the sober liquor. You
don't wanna
I'm with her with the whole ankle thing, because like if I go to work and then it just don't, I can't wear a dress.
is that true? Okay, all right. I'm just checking. Let's do it this way because your circumstances are a little bit different. Okay. I'll adjourn this to the 17th at 9. Then will that work, counsel?
April 17th at 9 a.m.?
Yes.
Yes, Judge.
Or whatever time whatever block you get it put into. Defendant to have no further missed test. All right. If you're still going through the medication protocol, if there are missed tests, I'm gonna need some documentation of something. Otherwise, I'm gonna follow normally what I do. Understood, ma'am?
Yes, sir.
Okay. All right.
Thank you very much, Judge.
Thank you.
See you live in about 2 weeks.
Yes, sir. See, but I was kind. I was. Court calls.
Good afternoon, Your Honor.
Good afternoon. Your name?
Tony Malone.
All right.
Your Honor, Ms. Malone is going to admit responsibility to double parking today. And, I have discussed it with Susan Longsworth, and who's not going to appear today, but I believe Ms. Malone would like to proceed without her.
That is correct.
She's a judge now.
Yeah, she's got.
Yeah, she's not allowed to appear with me anymore.
A lot of important stuff.
You know, and then when she was like a little attorney running around. And then the indignity of her not appearing.
May 10th, 2004. I remember the day she started.
In
That's
fact,
it.
I believe the last time we were here, she approached the bench and spoke to you about this potential
She did.
ship coming.
She did. And I kept telling her it was going to happen at some point. It was my feeling. Didn't have any inside knowledge, but I am having been part of her career because she appeared before me. I guess it was 2004, right?
Yep, it's 2004.
And I'll say publicly that I am so just very proud of her.
Oh, same.
She just an amazing person. So
Could not agree more.
the only thing that I'm upset about is another county got her, but that's because that's where she chose to live. Anyway,
I know, I'm in complete agreement.
yeah, I mean, it would have been, Washington would have been well served had she been here.
Agree.
In this courtroom session, the judge addressed multiple cases involving bond compliance and testing violations, beginning with Eternity Jackson's matter, which was promptly dismissed after the prosecution confirmed proof of a valid 6-month insurance policy, leading the court to dismiss the charge without objection. The court then turned to Anna Johnson's case, which involved several missed alcohol monitoring tests rather than any positive alcohol results. Defense counsel explained that Ms. Johnson misunderstood her testing windows, believing she was required to test only between 9 a.m. and 12 p.m., whereas the court records showed mandatory testing windows. Beginning as early as 6 a.m., the judge carefully reviewed the testing logs and noted that while Ms. Johnson consistently tested negative for alcohol, she repeatedly submitted tests late or missed them entirely. Particularly the early morning testing period, Ms. Johnson acknowledged the confusion, explaining that she had set her alarms incorrectly and believed she was testing on time, and the judge clarified that late tests are treated the same as missed tests under court rules. The judge warned her firmly that missed tests could legally be considered positive tests and stated that, under normal circumstances, such a report could justify immediate jail time. However, exercising discretion, the judge offered Ms. Johnson a choice: either continue with breath testing and strictly comply with the correct testing windows, or be placed on a scram alcohol tether. After discussing the restrictions and lifestyle impact of a tether, Ms. Johnson chose to continue breath testing and committed to correcting her alarms and compliance. The court adjourned her case to April 17th at 9 a.m., emphasizing that any further missed tests would result in serious consequences, potentially including custody or electronic monitoring. Defense counsel later added that Ms. Johnson had been undergoing treatment with a mental health specialist for panic attacks and sleep issues and had recently started medication that caused fatigue, which may have contributed to the missed tests. The judge acknowledged this explanation but made clear that any future missed tests would require proper medical documentation. The judge reiterated that while leniency was being shown, it would not be extended again without verified justification. The session concluded with an unrelated traffic matter involving Tony Malone, who admitted responsibility for a double parking citation. The court noted the absence of her former attorney, now a judge, and briefly reflected on her professional success before proceeding, bringing the courtroom proceedings to a close.